Just wait.
Okay.
Okay. Mpho, please call up the matter.
Thank you, my lady. As the court pleases, my lady, there is a matter between the Special Investigating Unit and CZAKHELE Enterprise, PTY LTD, and 19 others. Case number KN04 of 2022, appearing in the Special Tribunal of South Africa before Madam Justice Modiba, 26 October 2023. Lady.
Thank you. Counsel may place themselves on record.
Thank you, my lady. I appear for the 12th respondent, who's the applicant in the interlocutory application this morning, initial A, surname Nepal.
Thank you, Mr. Nepal.
May it please the court, your ladyship. My surname is Mgwekyana. I appear for the SIU.
Thank you, Mr. Mgwekyana. Sorry to keep you waiting. I've been trying to connect since around about 10 to, and I was not even aware that there are problems on my side until Ms. Mashidisho tried to get me into, until she alerted me that she can't see me in the lobby. I don't think this application should detain us very long because the issue is very, very lean. So I propose that I articulate how I understand the issue, and then I pose questions to Mr. Mgwekyana. Is that, are you happy with that?
I'm comfortable with that, my lady.
Mr. Nepal, are you comfortable with that? Okay. The issue, as I understand it, is whether there's still a live dispute between the parties, right? The SIU contends that there isn't a live issue because it intends amending its notice of motion, and the effect of that amendment is that it would no longer be either seeking relief and or proceeding against the 12th respondent. So there's no need for the 12th respondent to compel it to make available for inspection and copying the documents it's listed in its notice served for that purpose. And the 12th respondent contends that there's still a live dispute because the amendment has not been effected, because the SIU has not fully complied with Tribunal Rule 15.5. Therefore, it is entitled to an order compelling the SIU to discover, because it is still under an obligation to file an answering affidavit. Am I correct in that understanding?
My lady, with your leave, the 12th respondent's position is not only that the list remains alive for want of delivery of the amended notice of motion. It goes beyond that. And may I inform her, lady, that last night the SIU did deliver its amended notice of motion. It uploaded it. And
it wasn't sent to us. Mpho, did you receive it?
No, my lady, I haven't, unless if it's an issue with our emails.
I've just received a notification. It's just come through now, so I think that should be it. Okay, so they've now complied with Tribunal Rule 15.5.
yes, and the position is the following.
Only yesterday, only last night.
Last night, but the 12th respondent's position is that even that is not good enough, in that the effect of the amendment is simply twofold. One, it does not seek any monetary relief against 12th respondent and other employee respondents. And secondly, it does seek an order for costs against the 12th respondent and any other respondent employee that opposes the application, the main application. Now, the 12th respondent has already delivered his notice of opposition to the main application. So the matter stands, the main application stands opposed by the 12th respondent, and the applicant in its amended notice of motion seeks costs against 12th respondent in view of him opposing the application. Milady, in the main application, there are allegations that are serious allegations, and which the founding affidavit, in one instance, I think it's the paragraph 118, calls specifically upon the respondents to answer. Now, my lady, the amendment doesn't tantamount to a withdrawal.
Yes.
It isn't a withdrawal. It still seeks relief against the 12th respondent, and the 12th respondent is opposing the main application, and it can't answer until it receives these documents. So my lady is partially correct in terms of one of the grounds raised by the 12th respondent, who says, look, there's been amendments that have been withdrawn. The amendment has not yet been effected. But at the end of the day, the amended notice of motion doesn't take the matter anywhere further in regard to not being obliged to comply with the notice delivered by 12th respondent. That is our position.
Mr. Newpal, the issue that I've articulated is the issue that arises from your founding affidavit, right? The issue you now articulate arises from your reply. Is that not correct? You said that out in your reply. Because in your founding affidavit, your case is as I had articulated it, right? In any event, and it appears that what the SIU is trying to do is, because this is the position it asserts, that it is no longer proceeding against your client. That's the position it asserts, right? That it is no longer proceeding against your client. But the procedure it has followed is a wrong one. And that's why the issues you now raise arise.
My lady, we've lost contact with you.
Court order still sought. So if there's a court order still sought against your client, of course there's still a list between the parties. Clearly, if the Sorry, I don't know, my network is a bit unstable this morning. They didn't even need to file they didn't need to amend their notice of motion. All they needed to do is to file a notice of withdrawal and then tender costs.
That's correct, my lady. The practical way of dealing with this matter, in accordance with the rules, would be a simple one, a straightforward notice of withdrawal in terms of Rule 21.
Okay, is there any other thing that you'd like to
My lady, is just
emphasize, Mr. Newpal?
my lady, I've lost
Mr.
you.
Newpal?
My lady, I've lost contact with you over the last few minutes intermittently. So I apologize if I'm saying something that may not accord to what the ladyship may have said. But just to respond on the one point, and that is that in the founding affidavit, the case that's made out by the 12th respondent is he's opposing the application. He needs the documents to consider his position and to file an answering affidavit if needs be.
Please repeat what you just said.
My lady, I just want to deal with the one aspect, and that is in the founding affidavit. The 12th respondent's case is based on, inter alia, one, he's opposing the main application. Two, he requires the documents for purpose of considering his position and draft an answering affidavit. So the amendment is really a red herring in this matter, my lady, with respect. It doesn't deal with the real issues. The issue is...
Yeah, but Mr. Newpol, do you accept that if the SIU actually intends no longer to proceed, because that's what they are said, yet they didn't follow the correct procedure?
My lady, I've lost contact with you.
Right. I agree that the amendment, when effected, the effect don't have the are certain from you is whether you agree that if their intention is really no longer to proceed against your client and they file a notice of withdrawal and they tender costs as they should, then
my lady, there's nothing further to deal with. My lady doesn't have to even...
There's nothing further to deal with, right? Yes. Then there's nothing further to deal with. But we are here because of the obstinate position the SIU had taken. So what remains is the issue of costs.
Correct, my lady.
My lady, I'm not sure if it's an appropriate time, if I may, with your leave.
Not sure why my network is so bad today.
We can hear you now, my lady.
Okay. Yes, I'd like to hear from you. You said you are Mr.
Mkwekana, my lady.
Yeah. Yes.
My lady, firstly, I would like to specify this. Strangely enough, out of 15 respondents who are were at some point in a similar situation as the 12th respondent, only the 12th respondent seemed not to understand that the SIU was withdrawing its relief against the 12th respondent. The other respondents who had also filed their notice of intention to oppose had since left the fray. My lady, the notice of intention to oppose on its own is not opposition, because at some point it seems that my little friend says, since the second paragraph of the notice of intention to amend, which, by the way, my lady, the amended papers were filed not until yesterday. They were served to the respondents, 12 respondent attorneys. There is on the 17th of October. There's even proof in that regard. They were just not uploaded on the case line on time. That, my lady, you need to take into consideration.
Mr. Nvejana, please assist me.
Yes.
I've narrowed down the issues. Right?
Yes.
Can we just deal with the issues as narrowed down? I don't think it's going to assist to be all over the show in this matter. And it matters not the position that the other respondents have taken. They're not here. So let's deal with the case of this respondent.
Okay, my lady.
Okay, so you seem to, so the SIU now seem to accept that it hadn't fully complied with 15.5. So it's ground of opposition that there's no longer a list because it intends amending is not sustainable. Clearly, it's not sustainable, right?
That includes the filing of the amended notice of motion, my lady.
I'm saying the belated filing. the belated filing of the amended pages.
Okay, my lady, what about then the written communication that clearly stated that the SIU no longer wishes to obtain any relief against the 12th respondent? Because there was also a correspondent in that regard.
But that's not how you withdraw an action. That's not how you withdraw proceedings, Mr.
I don't know if your ladyship then view is that by following the incorrect procedure means technically and really that the 12th respondent verily believed that the SIU still intends to proceed against his client. And consequently, the relief sought in the interrogatory application was necessary until at this stage. Because that cannot be true, my lady.
Okay, Mr.
The procedure may be
I'm
incorrect.
simply going to allow you to argue your case, right? Because I don't find this engagement of assistance because you are skirting the issues. You are actually avoiding the issues that you need to respond to.
Perhaps
So let me allow you.
Understand you. Again.
Let me allow you to simply argue your case.
My lady, I don't want to detain you unnecessarily. Perhaps let me understand your ladyship's prima facie view.
So I've put to you that the belated filing of the notice of the amended pages, is it an acknowledgement that the SIU had not fully complied with the provisions of Tribunal Rule 15.5?
By filing the amended pages late, yes, indeed, my lady, was not filed timelessly.
So it's an acknowledgement that the SIU had not fully complied. So it's an acknowledgement that the amendment had not been effected.
My lady, without any doubt, it had not been effected.
Okay, so let's track back then. When was this application launched?
It was launched on the 21st of September. The notice of the initial notice of intention to oppose was on the 22nd of August.
That's not helpful, Mr. Mzishana. Okay. It's not helpful to go back that far.
Okay.
It's really not helpful.
Okay. The application was instituted on the 21st of September.
So when that application was instituted, the SIU had not complied with the request to discover, right?
Indeed.
And it had not effected its amendment.
No, only the notice of intention is, indeed.
So the application was not moot.
My lady, we must also bear in mind that the notice...
Mr. I'll allow you to explain yourself. I'm asking you a very direct question. The application was not moot.
When it was instituted, my lady, the notice also, in terms of the rules, it must allow the other party 10 days within which to object to the notice. That's what
all of that happened. We are at Tribunal Rule 15.5, right? So the 12th respondent didn't object. In terms of Tribunal Rule, I think it's 15.4, the amendment is deemed to have been consented to. So the ball was in the SIU court to file its amended pages. It did not do that.
Yes, yes, my lady, on until the 17th of October.
And I've got in front of me the instructing attorney's letter of the 22nd of September. So it's very clear in that letter that she was insisting that her notice of intention to amend effectively absolved the 12th respondent from the relief sought by the SIU and technically rendered the 12th respondent's request for document moot. That's the position she articulates in paragraph 4 of that letter.
I agree, my lady.
And that position was wrong, clearly wrong.
May I understand why, my lady?
I'm asking if you agree that that position was wrong.
My lady, I do not agree because we're simply saying we have filed an intent that we are going to amend our pages. Then that technically means your client will no longer need to participate in the application if we no longer seek a relief against your client. That then technically means we no longer need to discover your client, the documents that you require, since you were saying you needed the documents in order to prepare an answering affidavit. That's what that paragraph seeks to say.
You know, it's not helpful when counsel is not conceding the obvious.
My lady, I'm trying at best to.
Your duty is to this tribunal. The wording of the tribunal rule is actually very simple. It's not complicated.
My lady, if I may, just a second. I'll be with you now, my lady. I just beg your pardon for a second.
Okay, let's do this, Mr. Gwechana.
As it pleases, my lady.
Please take instructions on whether your client no longer intends to proceed with the legal proceedings it has instituted against this respondent. And if that is the case, whether it will file a notice of withdrawal and tender the costs of the application, of the review application and the costs of this application. Please take instructions on that.
My lady, I will for your.
Mr. Mgwechana?
Oh, my apologies, my lady. I will for the benefit of the tribunal.
I'd like to stand the matter down for that purpose. Is your instructing attorney with you?
Yes, she is. It won't take that long.
Okay, so how long? 5 minutes?
10 minutes, my lady, because she's gonna give a call to her superiors as well.
Okay.
Thank you.
Mr. Newport?
Thank you, my lady. I'm indebted to you. I think the stand down will assist all of us.
Okay. Matter stands down for 10 minutes, so we'll stand down until 11:45. Thank you.
Thank you. My lady, we may proceed.
Hello?
Thank you, Mr. Mkechana. The judge will come on.
Thank you.
Thank you. I'm sorry, Mr. Mkechana. Looks like we lost the judge, but she's joining back in.
Yes, Mr. Mkechana.
Please, the court, my lady. My lady, we couldn't obtain instructions in as far as the issue of us tendering cost is concerned, for the simple reason that there are internal procedures that must be followed within the SIU to obtain such instructions. My lady, without detaining you further, my lady, our case is well articulated in our papers. We cannot take the case any further. If your ladyship feels that the application was necessary, notwithstanding our notice of intention to amend and various correspondences that were exchanged between the parties, informing the 12th respondent that we no longer seek a relief against the 12th respondent, and that by virtue of us following an incorrect procedure, instead of sending a notice of withdrawal, we followed the procedure of amending the papers. Then it means the application was necessary. Then we cannot take the matter any further. The ladyship, we should make a ruling. But my lady, before you make that ruling, it is important to ascertain from the 12th respondent whether the matter, they now accept that the matter is moot, and at what stage. That means there's no live dispute between the parties, or is it only now? And if it's only now, what has changed? Is it only the argument that we are making now that there is no live dispute, despite letters? And if, because your ladyship should be mindful that the notice of withdrawal has not yet been filed. So it means if 12th respondent says, in the absence thereof, the matter is not moot, it consequently means the order should be granted as they are in the application, and accordingly award cost against the SIU. But what will be the effect of that order? Will it not be an academic exercise? So those are the issues that your leadership would battle with, we are saying, leadership, you should not ignore the correspondences, even if the procedure that was followed was incorrect or the amended pages were filed late. But you cannot turn a blind eye on a clear intent through correspondences that said, we no longer seek relief against your client. In as far as the paragraph 6 is concerned, we are in the reply, the 12th respondent says, it says, in the event of opposition, we seek cost order. That is a misdirection. A notice of intention to oppose is not an opposition. Even the rule 6(5), says intent to oppose. The matter becomes opposed once opposing papers have been filed. So because in the reply, they seem to say, to also bring that to the fore and say, had they not crafted that paragraph in that fashion, they would have understood that there's no live dispute between us, simply because they're still insisting on costs. Since we're filing opposing papers, then the dispute was still existing between the parties. But that's all I want to say.
Mr. Mgwejana, I just want to correct you. This matter doesn't turn on my feelings.
I beg yours, my lady.
When you started addressing me, you said, if I feel that.
My apologies for that, my lady.
It doesn't turn on my feelings.
My apologies, my lady.
I wouldn't be sitting here if I adjudicate matters based on what I feel.
My sincere apologies.
I have absolutely no interest in this matter. My role here is simply to hear the parties, consider their respective cases,
it's a correct word, my lady.
And give rulings based on the law.
It's a poor choice of word, my lady. The correct word, I think, should have been the view. I sincerely apologize for that.
Thank you. Mr. Lupo?
Thank you, my lady. 12th respondent is still left confused by the conduct of the applicant in the matter, but it would seem, from what I understand, that it intends withdrawing the proceedings against the 12th respondent. But no notice in that regard has yet been filed. The amendment that is referred to doesn't deal with the withdrawal at all. My lady, in these circumstances, I began by saying to her ladyship that if the main application is withdrawn, and that's the intention of the applicant, then the matter becomes moot, and really the tribunal time and everyone else's times and costs shouldn't be consumed. But I'm now left in a situation where it would seem that the applicant does not want to categorically withdraw its main application and proceedings against the 12th respondent. The rules provide for the process in terms, I think, of Rule 21 on the withdrawal. And it's a simple exercise to simply withdraw on that basis. So, my lady, the 12th respondent is still left in limbo in terms of precisely what the true intention of the applicant is. And in these circumstances, I must then ask her ladyship to grant relief in terms of the interlocutory application and request through the court again to the applicant to kindly consider its position and stop the continuance of unnecessary litigation with respect. And I say so respectfully, my lady, I don't understand the applicant's difficulty in regard to dealing with the matter practically and in terms of the rules, if his true intention is not to proceed.
Sorry, I had lost yes. Mr. Newport, I lost you about a minute ago. If you can just try and
yes. My lady, I was submitting to her ladyship and I was saying respectfully that the 12th respondent up to now is unclear on the true intention of the applicant. And if the applicant is genuinely not wanting to proceed against the 12th respondent, then it's a simple exercise with respect to deliver an appropriate notice and bring the matter to an end without wasting tribunal's time and costs. Now, unfortunately, we're not at that position at this point in time, and 12th respondent is now again left in limbo, and I'm going to beseech Her Ladyship to grant relief on the interlocutory application in the meantime, and through Her Ladyship, formally request the applicant to kindly consider his position and deliver an appropriate notice sooner than later, so that this matter can be put to bed.
Mr. Nupel, when I grant orders, I don't grant them in the meantime. Once I grant an order, it is enforceable.
Yes.
It's not an order I grant in the meantime, and I will not grant an order based on the SIU's intentions.
Yes.
It's an order that is enforceable. It's an order that will stand on its own feet. Right.
Yes.
If the SIU decides to follow the correct procedure, whether to comply with your request for documents or to fully comply with the rules in terms of withdrawing the proceedings, then it's up to it to do so.
I appreciate my lady, and I agree with Her Ladyship's expressions. And I'm left with the unfortunate position that I must ask Her Ladyship to grant relief on the interlocutory application for the 12th respondent.
Yeah, you've also brought an application to strike out. Are you persisting with it?
Yes, my lady, the strikeout application in the replying affidavit sets out the grounds, and the grounds are essentially those well recognized in law. The applicant.
Yeah, no, I'm simply asking if you are persisting with it,
Yes.
because it's a very simple, clear application.
Yes.
You are persisting with it.
Yes, I persist with it, and I ask that you grant those orders sought for strikeout together with costs.
Okay, Mr. Mgwechana, you didn't deal with that application.
My lady, I received the application late yesterday. We have not had a chance to even file opposing papers. So I don't think I am in a position to tender evidence from the bar.
Mr. Mgwechana, an application to strike out is an interlocutory application. It barely requires evidence. This is how these proceedings go. So what must I do? I mustn't adjudicate that application.
My lady, I really don't.
The standard of adjudication of representation by the state attorney is really shocking. And I'm following media reports on similar complaints in other forums. It's really shocking.
My lady, you should understand.
You should have come. You should have appeared today, ready to deal with that application. You belatedly, and when I say you, I mean the SIU, belatedly answered to the current interlocutory application. And within 24 hours of receiving your papers, the 12th. You should have come ready to deal with that application.
My lady, I cannot say anything further in as far as this is concerned, because you should understand my position. I'm precluded even by the rules to tender evidence from the bar. That will be unethical of me. I don't have an affidavit answering to that application. The application was received late afternoon. Even 24 hours that your ladyship is referring to, it has not yet lapsed.
So what should I do with that application? I shouldn't deal with it now because you don't have instructions.
My lady, I do not have instructions. Really, I have not been instructed. Really, I can't. My hands are tied. I cannot just
Okay,
tender.
I'm going to stand the matter down. I'll stand the matter down for you to take instructions in respect of that application. It's a very brief application. That replying affidavit mainly replies to Yes, Mr. Mgwechan, I was saying
I lost you
your
there.
client does not your client does not have a right to respond to the replying affidavit. But in that application, in the replying affidavit, there's a new application that's set out, right? Of course, your client has the right to respond only to that application. And I'm simply asking you whether your client intends opposing it. I hear you that you don't have instruction because that application was only received yesterday. Now, I need to know whether your client intends opposing it, and if so, how and when it should be heard.
My lady, if you may just give me a minute, perhaps it will be of assistance to your ladyship. Just a minute. Stand down for a minute. I'll take instructions. I'll have a discussion with my instructing attorney and the senior manager at the SIU quickly. Then I'll revert to your ladyship. Perhaps it will not be necessary to even come to that stage. That's what I'll seek to.
If you are seeking a postponement so that you deal with that application, bear in mind that you are escalating costs.
My lady, that's not what I've said.
Further papers. Yes, please hear me out, Mr. Mgojana. If you are filing an oral argument,
my lady, I lost you for a while.
An application, it's normally responded to. Yes, Mr. Mgojana.
My lady, I lost you. You just came back.
Can you hear me now? Can you hear me now?
Yeah, yes, I can.
Yes, I'm saying this application to strike out in terms of the uniform rules of court, and I think we do have an equivalent rule in the tribunal. I just can't remember the reference. It's a 611 application. It's normally dealt with on the papers. There's often no need to file answering affidavits and even heads of argument. It's normally dealt with on the papers. So the SIU should be mindful of that. And also be mindful of the implications of and seeking further oral argument on another day, because that simply escalates costs. So I'll stand down for a minute.
May it please the court, my lady.